And welcome back to Primetime News.
And a special welcome once again to our viewers on onespotmedia.com and on TVJ International in the Cayman Islands.
We begin this evening with a Primetime News follow-up. The Court of Appeal today overturned a 2020 Supreme Court ruling which had declared that a Portmore-based school did not breach the rights of a female student when it denied her access because of her dreadlocked hair.
But the Court of Appeal said Kensington Primary was in breach after demanding that the child cut her hair in order to attend school.
Details in this report.
Outgoing President of the Court of Appeal, Justice Patrick Brooks, in handing down the decision, said it is declared that the Board of Management of Kensington Primary on the wearing of dreadlocks hairstyle has breached the following rights as they related to ZV's rights. The judge noted that the child's rights to freedom of expression and the right to equitable treatment by a public authority in the exercise of any function were violated. The landmark decision overturned in part a 2020 decision of the Supreme Court that the school's policy did not breach the child's constitutional rights. The school had justified its position on the basis that it found that the hairstyle harbored lice and junjo infestation and threatened to withdraw their child's admission if the then 5-year-old student's hairstyle remained. But the student's parents, Dale and Shireen Virgo, who refused to cut their daughter's hair, instead filed a lawsuit against the school's board, the Education Ministry, and the Attorney General, arguing that the child's constitutional rights had been breached. But Justices Sonia Bertram-Linton, Evan Brown, and Nicole Simmons ruled that Kensington Primary School did not breach the child's constitutional rights when it denied her access. The court had also ruled that Dale, who was listed as the first claimant, had no right or capacity to bring the claim, a decision which the appellate court upheld. The claimants, however, had sought a number of orders from the court, including a declaration that the contentious grooming policy excluding dreadlocks was unconstitutional and breached the claimant's rights to freedom of expression, equality before the law, freedom from discrimination on the grounds of race, place of origin, social class, color, religion, or political opinions, among other reasons. But the Court of Appeal judges, in their ruling, had indicated that the matter was not about religious rights and freedoms, but self-expression. In the meantime, Attorney-at-Law Isaac Buchanan, who had represented the Virgos in the lower court and was instructing counsel in the case at hand, has hailed the case as a victory for the entire Jamaica while emphasizing that the court got it right.
Today is a great day for jurisprudence in the Jamaican space, especially just before the independence celebrations coming up not long from now. African identity, the Afrocentric expression was protected by the court, and I'm overwhelmed by it because as a Rasta man who wears dreadlocks as a part of my expression and my identity and my existence, this judgment was very important to me.